Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am VP Moolman from Maserumule, and in today's episode we will unpack what if an employer dismisses an incarcerated employee. Is there a right to a post-dismissal hearing? Now, just about the only thing we know for certain when it comes to the employer's obligations towards employees who have been imprisoned for conduct that is not work-related is that imprisonment suspends the employer's obligation to remunerate the employee for the period of the employee's imprisonment. But may an employee be dismissed for being in prison? And if so, at what point? In other words, how long must the employee have been absent for? And what does one dismiss the employee for? Do we dismiss the employee for capacity or operational requirements? Now, back in 2010, in the Salmon Court Tabatsa Ferrochrome matter, the Labour Appeal Court referred to operational incapacity based on an employee's physical inability to tender his services. In this matter, the employee was fairly dismissed on the basis of his incarceration and the commercial need to fill his position. Now, as you are aware, in all dismissal cases, the employer must follow a fair process, which includes an employee's right to have a fair hearing. However, affording an incarcerated employee an in-person hearing is often impossible, and incapacity proceedings will invariably have to be held in absentia. Recently, and in the Nzoru versus Transnet National Ports Authority matter, the court considered whether an employee dismissed for operational incapacity in absentia is entitled to a post-dismissal hearing after being released from prison. Now, in this case, the employee requested leave for 5 days, but only 1 day was approved. But regardless of this, the employee took more than 1 day, and while on leave, he was a victim of a hijacking in which he shot 2 persons. He was arrested and detained in Limpopo. Pending his trial, his bail application was refused. The employer conducted an incapacity hearing. The notice of the hearing was given to the employee's spouse to convey to him. The employee requested that his trade union represent him, which it did. Following the hearing, the employee was dismissed for incapacity, having been found guilty of failing to discharge his duties from 28 May 2019 until 18 July 2019. Upon his release from prison, he referred an unfair dismissal dispute to the bargaining council, but the arbitrator found that his dismissal was procedurally as well as substantively fair due to the uncertainty surrounding his incarceration and the need to fill his position. The employee took the matter on review to the Labour Court, and he argued that his dismissal was procedurally unfair as he was denied the opportunity to state a case by virtue of a post-dismissal hearing. The Labour Court disagreed with the employee. The court pointed out that the procedural fairness of the employee's dismissal depends on the adequacy of the hearing he was afforded when it was held in absentia, and whether the failure to hold a post-dismissal hearing meant that any defects in the original hearing were not rectified. The court held that there is no general right to a post-dismissal hearing in cases of incapacity due to incarceration. It found that in cases where a post-dismissal hearing takes place, it is usually because the employer did not notify the employee that the hearing will take place or was taking place in their absence, or that the post-dismissal hearing was provided for in the employer's disciplinary code. The court held the established principle is that an employee must be given an opportunity to present their case before being dismissed. This we know. The court held further that an employer who is uncertain about when an employee will return to work cannot be expected to wait for the employee indefinitely, and that it is entitled to decide whether it is still feasible to keep the employee. A hearing in absentia can take place provided the employee is given the opportunity to make representations, which representations can also be done in writing. The court in this case, ladies and gentlemen, then found that the employee had failed to properly argue why the original hearing was not fair, which would have justified the need for a post-dismissal hearing. His dismissal was found to be procedurally and substantively fair, and the review application was therefore dismissed. So, ladies and gentlemen, in conclusion, the key point is that if an employee is in prison, an incapacity hearing may be conducted in their absence. But nevertheless, the employer must still guarantee that the employee has a chance to present their case before deciding to terminate their employer. A post-dismissal hearing is not a guarantee or guaranteed entitlement, but it may be necessary in certain cases where the employer did not provide the employee with an opportunity to state their case or to correct any deficiencies in the initial hearing conducted in the employee's absence. So that then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media or email us at info@masconsulting.co.za. If you are interested in staying up to date with the latest news and insights on employment law, be sure to subscribe to our Spotify and YouTube channels. Thanks again for tuning in. I'll see you next time. Bye-bye.